Hello, welcome back to another Men's Divorce Podcast Live. This month, the panelists of Cordell and Cordell Divorce Attorneys will answer your questions live and discuss the divorce of Tiger Woods and Elin Nordegren. My name is William House, a litigation partner here at Cordell and Cordell in St. Charles, Missouri. Cordell and Cordell is the world's largest domestic litigation firm of its kind, advocating for fathers before, during, and after divorce. With 30 years of experience in all facets of family law, we are a partner men can count on. Please make sure to submit your questions in the chat sections on YouTube and Facebook Live. We are also streaming on LinkedIn, so a quick hello to everyone out there on LinkedIn. Men's Divorce Podcast Live is a special monthly series hosted by Men's Divorce Podcast and sponsored by Cordell and Cordell. If you would like to listen to more topics regarding divorce or family law, subscribe to the Cordell and Cordell YouTube channel. As a reminder, you can schedule a virtual, in-person, or over-the-phone consult with one of our attorneys by calling 866-DADS-LAW or visiting our website at cordellcordell.com. And we are attorneys, so of course we're going to give you the disclaimer. An attorney-client relationship is not established through this webinar. We do encourage you to contact our office directly for any legal advice. So now I'd like to start by introducing our panelists. First, we have Thomas Gross, a senior lead litigator out of our Frederick, Maryland office, and Egers Vangili out of our Independence, Missouri office is a litigation attorney. Morning or evening.
Yeah. Hey, Will, thanks for having us. So you win Best Beard again one of these days.
One of these days.
Egers keep trying.
Yeah, I'll keep growing it.
All right. So before we get into it, we're going to take a quick commercial break and then we'll jump right into it. So, as I mentioned at the outset, today we're going to be talking about the Woods-Nordegren divorce. Quick overview for those of you who may not be as familiar with the details of this divorce. Tiger Woods and Elin Nordegren were introduced to each other in 2001 by Swedish golfer Jesper Parnevik when Nordegren was nannying for them. They married on October 5th, 2004 in Barbados in a private sunset ceremony where 200 attendees were present, including celebrities such as Charles Barkley and Michael Jordan. In June of 2007, they became first-time parents to Sam Alexis Woods, and in February of 2009, they welcomed their son, Charlie Axel Woods. The day after Thanksgiving 2009, Woods crashed his Cadillac Escalade outside of his Florida mansion. Some of you may remember that. Nordegren, claiming to be trying to rescue Woods from his crashed vehicle, used 2 golf clubs to shatter the rear view windows of the vehicle. That same year, reports were made that Woods was unfaithful in his marriage after dozens of women came forward alleging their sexual relationships with Woods. After the scandal, Woods lost most of his sponsors, and as a result of the scandals, his golf game began to suffer as well due to physical ailments and a loss of focus on the course. He went from number 1 in the world to number 1,199. Woods and Nordegren finalized their divorce on August 23rd, 2010. The couple tried for months and months to reconcile, but finally they agreed they were unable. Now, Tiger Woods had a prenuptial agreement, or anti-nuptial agreement, sometimes you'll hear that term, with Elin Nordegren, stating that if they stayed married for 10 years, she would receive $10 million from him. Initial reports stated that Nordegren's divorce settlement was $750 million, but she actually walked away with right around $100 million. Following the scandal, Woods reportedly tried to get Nordegren to stay in the marriage longer so she could receive her $20 million as stated in the prenuptial agreement. In 2018, a source informed People magazine that the pair were getting along just fine and that they were friends now. And Woods and Nordegren share custody of their children. And just 2 months ago, were spotted together at their son Charlie's state golf championship in Palm Beach Gardens, Florida. So, at least at this point, somewhat of a amicable, if not happy, ending. So, a couple of issues you may have picked up on in that summary. The big one was the prenuptial agreement. Woods actually had tried to bribe Nordegren to stay in the marriage using the prenuptial agreement and what she would gain to benefit out of the terms of that prenuptial agreement. So I want to talk a little bit at first about the pros and cons of a prenuptial agreement. Let's start off. Tommy, I know that you've done a little bit of work on prenuptial agreements. What are some of the things that come to mind just off the top of your head as pros and cons for prenups?
Sure. Thanks, Will. So first, I would say the pros of a prenuptial agreement are, in most cases, it spells out everything you're going to need to know in resolving your divorce, especially when it comes to property, alimony, attorney's fees. These things are really intensely stressful. And I think if you can have those things resolved beforehand, everybody has an expectation of what will happen if the marriage fails. That is a big pro of having a prenuptial agreement. And I don't know Mr. Woods or Miss Nordegren, but I would be willing to venture a guess that one of the reasons that they're successfully co-parenting their children, and congratulations to them for that, is because they understood what property was going to be at issue if they broke up. Settling those disputes reduces conflict and helps them move on to what's really the most important aspect of any family breaking up, which is raising their children. Cons, there can be many cons, especially depending on who drafts the prenuptial agreement. A lot of times people think it says something it doesn't say. There's a lot of sort of catch-alls. I can think of one recently. It was a very well-drafted prenuptial agreement, but there was a last paragraph that said if the party's marriage survives 5 years, then all the preceding paragraphs are void. Now, prior to that, there were paragraphs saying these don't apply, but it didn't specifically reference the last paragraph. And when it comes to a divorce, a big part of the expense, in addition to trial work, is the lawyer managing risk for the client. So if your prenuptial agreement says two things or isn't clear, the risk is still there that you might not get the benefit of your bargain. And that's a pretty big con.
Yeah, definitely. You have to be very clear. I mean, essentially, we're talking about a contract here, right? I mean, it's a contract for what happens if and when you get divorced. And just to be clear, I mean, prenuptial agreements also apply in the case if one spouse predeceases the other spouse. So it's not just for in case of divorce, but often that's usually the time when we're talking about it, and obviously it's the time when we as family law attorneys are talking about it. Eagers, with a prenuptial agreement, a lot of work goes into before the fact, right? You have to lay the groundwork very well, and as Tom said, very clearly when you're drafting this, so that it'll affect the terms that you actually want. What are some of the things that we need to consider when we're drafting prenuptial agreements, and when the court will ultimately be looking to enforce those prenuptial agreements?
Thank you, Will. Well, the first thing is timing of it. Oftentimes we've encountered in our practice parties wanting to draft a prenup a week before the wedding or days before the wedding. And that's a red flag, even if it was mutually agreed upon. There is something to happen down the road if a divorce is to happen. The court also looks for clarity. The court looks for certainty on the provisions of these prenuptial agreements. So when, for lack of better words, all goes south, then there isn't a litigation battle for months and months, if not years, and thousands of dollars in attorney fees to trying to figure it out what was meant when the prenuptial was drafted.
Yeah, and with that, I mean, being very clear, a big part of prenuptial agreements is complete disclosure, right? You can't enter into this type of contract and, be hiding assets or hiding income that you have available to you, because another big factor in this is whether or not each party had access to an attorney. Now, if you've got somebody like, Mr. Woods and Miss Nordegren, they've got plenty of money to be hiring their own attorneys before the fact, and they'll go through these terms and they'll, make sure that it says what they want it to say, and it'll effectuate those terms if and when, as you said, things go south. But making sure that they've shared all that information with their attorney beforehand is vital. And you don't actually have to be represented. It's just a question of, did they have access to that attorney? And if they chose not to, you're allowed to do that. But, generally speaking, it's preferred by the court, at least in my experience, that both parties have representation. So that's another thing that you need to think about when you're going into it with your soon-to-be spouse is, okay, I've got my attorney. Who's going to be their attorney? You're kind of covering your own bases by making sure that the other side has representation as well. And it may seem counterintuitive because, well, why do I want them to get legal advice and make sure that they're protected? As you said, Egers, if you don't do that, you're spending good money for something that may not be enforceable in the long run.
And let me add to a little bit of what Egers was saying. It's transparency is key, because when you're entering into a marriage and you're betrothed or fianced or whatever, it could be considered a confidential relationship. And so the closeness of your relationship to the other person can be used as a defense to a prenuptial agreement when the marriage fails, to argue that the terms shouldn't be held against whoever they'd be held against. They frequently would make the defense that they didn't have time to review it, Will, which is what you were saying, not enough opportunity to consult with counsel. If you don't disclose bank accounts and state it in the agreement, a judge could easily throw it out and say this is unconscionable, or I find that it wasn't, there wasn't enough disclosure here. And the problem that you have with these kinds of contracts is there's sort of, and Will, as you were also saying, it survives the marriage. It could go on to the death of the spouse. So you're looking into perpetuity and trying to decide, well, what is going to happen when the law changes, when the judges are gone, when we don't like each other anymore. I mean, prenups are not known for their romantic value, but you're still entering a marriage at that time. So there's still some goodwill. What's life like in 20, 30, 40, 50, 60 years? And what did we mean when we say that? It's got to really all be written there, or else it's really easy to undo it.
That's right. So one of the things that also I think it's important for people who are listening to be aware of is that even though we try to address as much as we can in a prenuptial agreement, it's going to be limited in scope of what it can address, right? Because we can't address things like child custody or child support. It's just in my state, I know that's the law, and I would venture to guess that that's the law in every state, because child custody and child support are related to the best interest of a child. And so that can change over time. So you can't enter into a contract saying, well, this is what our custody agreement is going to be, or this is what the child support amount is going to be, because those things are variable and that falls within the court's exclusive purview. So we can't contract around those things. And that kind of leads us into our second topic here, talking about there was a specific provision in the divorce settlement agreement that Woods and Nordegren entered into. There was a stipulation that even though the parties had joint custody of their children, Woods was not allowed to bring them around a woman unless he planned to marry her. And this is sometimes we'll refer to this type of clause as a morality clause. Some of you who are listening, maybe you've experienced this. You've had difficulty in enforcing a provision like this. Eagers, how would you even begin to enforce a provision like this?
Yeah, so this screams for unenforceable. We see this provision a lot. Obviously, it's very vague, and there is no way of determining what plan the person has. So, for all we know, Mr. Woods could say, "Yeah, I plan to marry this girl this week, and then I plan to marry a girl next week." So every week he gets to introduce his kids to a different girl. Um, and while you can try to enforce it and file a contempt action or whatever the appropriate action might be on that particular jurisdiction, the only thing that is likely or most likely to happen at the end of the day is a very contentious litigation, thousands and thousands of dollars of attorney fees, more spite between two people that probably already don't like each other without any resolution at the end of the day, because the way it's written as is, it's very vague and likely unenforceable. So
Okay. So with enforcing an agreement, whether it has to do with property, custody, anything, that's through a contempt action. But again, we kind of go back to that drafting. Today that's been a little bit of a theme of what we're talking about is drafting, first with the prenuptial agreements and now with this clause that was in their custody plan. Thomas, why is drafting so important when we're looking at trying to resolve a case? And what are some of the pitfalls that people can try to avoid when they're drafting an agreement to reflect what they actually want to occur?
Well, I mean, it's the written word, right? And it's, the word should be law, but unfortunately, everything is interpreted through our 2D eyes, and the person that's going to be reading that and enforcing that often is a judge who doesn't know you, didn't participate in the drafting or the negotiation, knows nothing about your family. And this is not a comment on judges because they care very much, but frankly, there's just so much care one person can provide. And when a lot of these judges are hearing criminal cases, it's just not always there for the family law case. You've got to be very specific so that when a judge looks at it, they say, there's no way to read this any other way. And that's a gift that you really look for in a draftsman, is somebody who can write something in a way that it can't be interpreted as too vague. And pitfalls abound in this area anyway. I agree with Eagers that the provision that you can't introduce your children to any female unless you intend to marry them is so vague, but it is frequent in prenuptial agreements or even settlement agreements. It's analogous to me of like the right of first refusal, which I don't know if you guys have dealt with that type of language, but what that usually is if you're not available to have your children for your scheduled time, you must offer them to the other parent before seeking other alternatives. And that, I think, in almost everybody's mind encapsulates the idea that dad has to go to work and is traveling and therefore is not available, so offers the kids to mom before getting a babysitter. But it frequently is used to prevent grandparents from being involved. I had a trial on this issue. It wasn't in a prenuptial agreement, but it was in a settlement agreement, which could be considered an antenuptial agreement, but then they get divorced. And it was a right of first refusal for 3 hours unless the children were in school. Now, in my state, we had lockdowns during COVID, and school was remote for a large portion of that time. And so our client would allow his fiance to monitor the children while they were doing distance learning. And the mother filed a contempt because she wasn't being offered the right of first refusal. And we had a full-on trial for it. And the judge was very considerate. It actually turned out to be a harder decision than you would think. And we argued they were in school, so it wouldn't apply. Judge said, no, it's a failure to provide the right of first refusal. So in these things, drafting is so important because you just can't even envision all the ways in which a word could be interpreted against you.
Yeah, that's really interesting as it applied to distance learning during the COVID lockdowns, because that's exactly to your point. You can't anticipate every future event. I mean, none of us would have anticipated at some point that, kids would be required to do distance learning. And then beyond that, how that would apply when we're talking about school. Because I thought you were going to say the other way, that the judge said, oh yeah, they're in school. That's their school now. So that's the way. But it just goes to show it's interpretation. If it's not black and white, absolutely crystal clear, then there is that risk of interpretation where somebody else is going to look at this and they're going to say, well, when I look at this, this is what I see that this means, or this is what I think this means. So I think that's really, really important to think about, is not only, what's the language we're using when we're drafting it, but also how is somebody else going to look at this down the road, and is there some other possible interpretation? And again, it's not to say that we're going to be able to think of every single possible interpretation, but it's about minimizing risk and trying to avoid those future issues in figuring out, all right, well, what do we mean by that, or what are we going to do about that? Kind of shifting gears a little bit, still on the same topic of child custody, what are some other elements or areas that you want to consider when you're drafting a parenting plan? And maybe your client has a specific concern, maybe something that's been brought up to you recently that's sort of outside of the cookie cutter parenting plans that we see in every case, but maybe there was something special in a case. Egers, I know you've had some of those cases that we've talked about where there's just some specific terms that we needed to get into that parenting plan to address an issue for a client.
So this happens a lot, whether it's a divorce case or a modification case. Sometimes we deal with a third-party known parent that has a drug or alcohol issue, or gets a DWI, and we would enter specific provisions that this person, this third party, is not to drive the children to and from school, or to and from visitation exchange, or anything in between, basically. So.
Yeah, there's endless when it comes to that stuff. I mean, when Egers, you were talking, I was trying to think what's the strangest provision I've ever put into a settlement agreement or a prenuptial agreement. And it's actually hard to come up with an example, because I feel like I spend a lot of time trying to shoot down like such specifics, because just like the Tiger Woods and Elin Nordegren example, and you try to be so specific and you end up hamstringing yourself in a situation where something unforeseen comes up. That's really the art of the draft right there, is creating a framework that will apply in situations like, who knows what, like, I'm going to sit here and waste airtime trying to think of what the next unforeseeable thing is and then earn my salary. But, you want it to be loose enough that it can allow for flexibility, but strict enough that somebody's not getting over on the other person.
Right. I mean, a lot of times it comes down to the party's ability in the future to work with one another. And if there's wiggle room and one party is going to take advantage of that wiggle room, there's really no way to draft around all possible wiggle, right? We can't avoid all of that. And so it's a question of, do we spend the time to try to draft everything so specifically that there's no doubt about what's going to happen in situation A through Z? Or do we draft it so loosely that it's essentially a free-for-all, and if the problem that arises is big enough, we have to come back to court and we have to have a judge interpret it? And you can get into things like parent coordinators. We could get into topics about mediating disputes, all of those sort of things. But in terms of child custody and the elements that we need to consider, I mean, there are very specific things that we have to include, right? We have to include what the custody schedule looks like. We have to include who's going to have legal custody, decision-making rights, right? Who's going to be able to weigh in? Who's going to be able to say yes, no, or otherwise? If anybody on the chat has any sort of examples of things where you've had that, come up where there's been a disagreement or there's been a misinterpretation or a disagreement about what the parenting plan means, feel free to list it in here. And, we'd like to hear some of your examples as well. I mean, as attorneys, we could tell war stories all day, but this is here for you all. So we want to, answer any questions or address any issues that you all have experienced. But as I was saying, with child custody, there are specific things. I mean, even our statutes require us to address holiday time, to address summer vacation time. But those sort of things are the basics, the foundation. And then we can put as much or as little into those agreements, as the parties want and as the parties can agree on. I had a judge tell me one time, creativity stops when the gavel drops, right? And what that means is we can be creative as drafters. We can be as creative as the law allows us to be, which is frankly pretty creative, up until we get to trial. And then once we get to trial, the judiciary is generally not going to be very inclined to be creative because they're constrained, right? They have some constraints that we don't have on us until we get to trial, because we can be creative. We can agree to things that the law may not necessarily provide the court the authority to do, like in my state, putting a parent coordinator into effect, a third party who's going to be able to come in there and make a decision without the parties having to go back to court. That's something we can do. But a judge cannot do that. They can sign off on an agreement, they can approve an agreement to do that, but they can't do it themselves. So a lot of it comes down to, what's required and allowed under the law versus what can be agreed upon between the parties through a mediated or negotiated agreement.
Yeah, one great thing to include in there, though, that seems to get everybody's attention is attorney's fees if you lose. There's one thing I think even the most disagreeable parents can agree on. It's expensive to fight with lawyers. And when you put that risk in your settlement agreement that says that if any party is found in breach or has to have this agreement enforced against them or seeks the enforcement of this agreement and loses, they'll be responsible for the other party's attorney's fees. That has a break on somebody's eagerness to take advantage or challenge the other. That's sort of like that's one thing I like to include in my agreements that helps keep people walking the straight and narrow.
Yeah, and that's something that we see in prenuptial agreements as well as in settlement agreements, just to kind of put that little carrot out there to say, hey guys, let's make sure that we're entering into this in sort of good faith and that we're all going to abide by these terms, and we're not going to try to manipulate these sort of terms so that we can get one over on the other parent or on our former spouse.
Yeah.
All right. Well, I see that we are kind of running out of time today, so I just want to say thank you to all of you who have joined us today. Please visit cordell.com or call us at 1-866-DADS-LAW so you can get in contact with a Cordell and Cordell attorney near you. As a reminder, we have virtual consults. We can do those through Zoom. We have consults over the phone, or we can meet with you in person at one of our offices. Also, be sure to check out the other men's divorce podcasts, both live and recorded. You can check them out at all of our social media and also on our website and mensdivorce.com. And finally, the live webinar today is presented and produced by Lexicon, a legal technology company. Thank you guys so much for today, and we look forward to seeing you next time. Eagers, Tommy, thank you for joining.
Thank you, Will.
Take care, Eagers.